Hello and welcome to the Law School Playbook. Today's topic is Introduction to Exams, and we're going to discuss strategies and common mistakes. This PowerPoint looks a little bit different than my other ones. It has a whole lot more text than I typically include, but I wanted you to be able to sort of just reference this and have all the information that you need rather than necessarily listening to the whole presentation again. But I am going to walk you through it because this is a really important one to get acclimated to the type of testing that we do in law school. So the first thing I want to talk about are the differences between law school exams and undergrad exams. The biggest probably difference right out of the gate is that you have far fewer assessments than you did in undergrad. In most first-year law schools, you may have just a final. Schools are working to develop more assessment and provide more assessment, so you may be lucky enough to have a midterm and a final. For example, the law school where I work, we just started implementing a midterm week during the first year so that the students at least have some experience with testing prior to the final exam. Overall, there are far fewer assessments in law school as compared to undergrad. In terms of the style of testing, there are essay exams, and those are quite common, particularly in first-year courses. Issue spotting exams, bar style multiple choice. So those multiple choice are a bit different than the multiple choice that you're used to. Just to give you a preview of those, the multiple choice in law school generally have two correct answers. One is more correct than the other. We call the other one the distractor answer, but those are the type of multiple choice questions you're going to encounter on the bar, and that's why we use them in law school. And then some, but fewer professors use short answer on their exams. Your writing ability plays an important role in how well you do on exams. And this means using the formulas that we've discussed in some of the other videos, like the IRAC paradigm, CRAC, CREAC, whatever it is, but your ability to use the formula as opposed to write beautiful prose like you may have if you're an English major. So as I said, the first year is primarily issue spotting essay exams, and what that means is that the professor will provide you a fairly lengthy hypothetical, so a set of facts. You need to read through the hypothetical, spot all the issues, and then analyze those issues using the relevant rule of law. So, this is, again, is when you're going to use IRAC and mini-IRACs, marrying the law and facts. And I have another video introducing you to that concept. So if you haven't viewed that video, you may want to stop now and go ahead and check that one out. And it may provide you some additional context to what we're talking about here. Before the exam, preparation is the key. There's a tendency of first-year students to focus on being called on in class because the idea that you are going to be called on using the Socratic method is just so scary for some students. So the vast majority of students make the very common mistake of really doing their homework and reading and briefing cases just with an eye toward performing in class. And it's a mistake. Everything that you do on day one should be done with an eye toward the exam. So when you brief, when you read, if you take notes instead of briefing, either way is fine, but it should be done for what do I need to know later on? Okay, why am I learning this? What am I supposed to take away from this to use on the final exam? And you're eventually going to outline all of your notes on your briefs, the things that you have prepared, and you are going to eventually condense them down to what you need and possibly create a flow chart. And how you study may depend on the type of exam, whether it's multiple choice, issue spotting, whether policy or the reason for the rule is important to your professor. Really try on day one to think about the final exam or the midterm, whatever assessment you have first, and how am I going to use and need this information, and really have that be your objective instead of just performing in class, which generally you're not graded on. This is something different from undergrad. Practice tests are critically important. And if you perhaps were an education major or you're interested in educational science and learning science, you probably know about the testing effect and a great book called Make It Stick. All you need to know is that forced retrieval contributes to your learning and memory. So, what that means is if you practice recalling the information and really testing yourself on your knowledge and your ability to work through a hypothetical and apply rules to facts, you are going to realize the depth of your knowledge, the strengths, the weaknesses, far before you get in the exam room. And that's in stark contrast to, for example, reading over your notes to just familiarize yourself with the content. That gives you a false sense that you understand the information in a way you may not. And there's nothing worse than the feeling of figuring that out when you're in an exam room. So you really want to spend a fair amount of time doing practice tests or working through hypotheticals, even if they're not whole tests. Those hypotheticals you use in class where your professors change the facts of your case and see how the rule now applies are critically important for you not only putting it into your memory, but really truly learning the material and engaging with it on a deeper level. So, where do you get practice exams? You get them from your professors, from other professors. You can use bar questions, commercial publications. So, there are all sorts of sources. There's books like Examples and Explanations. That's one I often refer students to in torts, for example, and those have questions and they include sample answers. There are all sorts of practice materials out there. Callie also has some as well. And so, how are you supposed to use those? Well, you want to mimic exam conditions to the extent possible. Now, time may not always permit you to do a full practice exam, even if you just sit down to write a hypothetical, that is helpful, or if you're just outlining an answer. But you want at some point to at least do some practice exams under exam conditions just so that you could get used to the timing and work on that skill. What should you do with them after you're done? Exchanging answers with your study group or a friend that you've made in class is always helpful. The thing about practicing in law school is you always have to do what I call the back end work. And I often analogize to a free throw practice. So you wouldn't just shoot a free throw and if you missed, walk off the court, or even if you made it, walk off the court and not continue to practice and analyze, what you did well, what helped you make it, what helped you miss it, and try again. So the key to doing practice exams is really using them to help you assess the strengths and weaknesses of your writing and of your knowledge. So if you listen to the intro to legal analysis or the IRAC video or watch that, you heard me talk about a method where you can check how well you're IRACing something by using highlighters. So yellow and green, yellow for the facts, green for the rule, and seeing that your analysis contains both colors. You could also go through and label each of your sentences with an I, an R, an A, and a C to see how well you are using the IRAC paradigm to organize your answers. And then you're going to use your practice exam answers to identify weaknesses in your course summary, whether that's an outline or a mind map. I have a bit about that also on my website, lawschoolplaybook.com, about the interplay of practice questions and your outlines, but it's really important that you use them as a learning tool, not just take them and walk away and say, well, I did what I was supposed to do and took practice exams. No, you're supposed to use them to help you gauge your understanding. So that's part of being a self-regulated learner. We've talked about metacognition and thinking about your thinking. And this is a way for you really to assess where you are, which is critically important because unlike other educational contexts, you may be in a class where you don't get a whole lot of feedback from the professor until, game day comes. So it's important too that you go see the professor. So maybe your professor is one that's willing to look through your practice exam answers and talk to you about it. Maybe your professor gave you a rubric to use, in which case you can try to quote unquote evaluate it yourself and then go see the professor with outstanding questions. So, really make use of professors also as a resource. I hear every semester, well, I offered practice exams and I really haven't gotten any. And I think it's not that students don't care about doing them, I think it's time is demanding. But like I said, it's better to do a quick one or part of one than none at all. So try and really schedule in those places where you can practice. And, if you're interested in learning more about scheduling and time management, I also have a video on that as well. That's before the exam. During the exam, how do you do it? How do you even approach it for essay exams? I will say there is a strategy to this. So it's not like it's something that requires some thought, I guess I'll say. So I want you to practice your approach when you do those practice exams under exam conditions. And so part of this involves pre-reading. So reading the instructions completely and carefully. I can't emphasize this enough. Law school is very much a reading test, as is frankly the profession of law. I have students every semester that have a hard time with this. And again, it's not because they don't care or they're being sloppy. It's that taking an essay test or really any exam in law school is very stressful. And so nerves will take over. And so I've had students who've missed a statute provided, missed an entire page of the exam, so an entire question. If you write a beautiful exam answer to a question that wasn't asked, you're not going to get any points for that. So really try and take a deep breath and read the instructions completely and carefully. And then you're going to scan the entire exam once quickly. What's in here? What am I facing? How many questions? How's it broken down? Does it have their worth? Does it allocate a certain amount of time for each? So really just scanning it and checking it out. And you are going to prioritize and budget your time. So you have in most exams the ability to decide which question to answer first, but you want to not sort of choose the one that you like the best. You want to be sure to spend a proportional amount of time based on the value of that question. So there's some decision making on your part for most exams as to how you'll approach it. But one thing I want you to really think about that you probably have never thought about for other exams, and that is the first problem that you encounter when you receive an essay exam in law school, or really any type of exam in law school, is the math problem. Figuring out how much of your time you're going to spend on each section and how much of your time you're going to spend on planning. And so we're going to talk a bit about that, but I feel very strongly that that's a necessity and it really keeps you on target. So we'll get into that a bit more later. In terms of looking at the substance, my colleague calls this a panic read, the first read. I don't love the term panic read because that implies you're panicking. I like to think of this as just an initial read. So, because the point is that you want to do more than one read of the essay. So, what you're going to do in this read is rather than marking it up, you're really just trying to take it in. You're looking for the call of the question, and the call of the question is something we refer to as, it really is what the professor is asking you to do. What legal problem are you trying to solve here? Is the professor asking you to analyze certain issues, to rule on a motion? Does the question place you in a role as an advocate? So it would be persuasive, or a judge, which would be objective, so weighing both sides. So these are really important considerations. And then it may limit some things. So it may limit the parties you're concerned with. Assume a battery claim can be brought against this person, focus on person B, right? Those might be in the instructions, in the call of the question. There might be other instructions. Assume that the element of intent is satisfied and analyze only the remaining elements of battery. And then if you wrote an answer that talks about intent when the question told you to assume it was satisfied, you are not going to get any points for that. So your idea is to, at this stage, just identify the main issue and really hone in on the call of the question and what you're being asked to do. Okay, so the second round of reading is when you start to dig in a little deeper. On this read are going to identify the key facts and issues and begin to outline your answer. So you're going to underline key facts, make marginal notes of the issue spot line by line, identify the rule. Okay, I'm looking at all these facts and it sounds like it's wanting me to analyze assault and battery on this torts question. So you look for facts relevant to each element of the rule. So if you watched my intro to IRAC or intro to legal analysis video, we did use battery there, and the rule we gave in that case had 3 parts to it, 3 elements. And so in that case, you would look for facts relevant to each element. And then, are there any exceptions that might apply? Further consideration is that you want to look for facts that cut in the opposite direction or that might be raised in a counter argument and write them down in your outline. This is something that's true 99.9% of the time. Rarely is there an irrelevant sentence in a law school exam. If you think it's meaningless, think again. So you may be missing something. So professors work very, very hard on their facts for these exams. They draft them and refine them and include lots of detail for a particular reason. And so if you are glossing over things and only finding very minimal facts that seem to be important based on the fact pattern, you are likely missing either a claim or counterclaim or an element. So you really want to try and figure out why each sentence is in there. This one I feel so strongly about. So most of law school study skills and even test taking skills, I feel like, well, you know, as cliche as it is, you have to figure out what works for you. Outlining and organizing your answer is not one of those. It is the one rule that I feel is you have to follow in order to be successful. And so what the advice I would like to give you here is, remember I mentioned the math problem that you do at the beginning of the exam? Well, part of that math problem is figuring out a quarter of your time and spending that quarter of your time as your thinking time to organize and outline your answer. This one's pretty neat because I typed it here, but yours is just going to be jotted down on a piece of paper, a piece of scrap paper very quickly. So an example of an outline where an answer is organized prior to writing. As you're reading the question, you might write something like this. Mary versus Joe, it's a battery claim. I'm going to remind myself what the rule statement is. So the rule is a general proposition of law that is applicable to any case based on similar facts. So battery is an act that intends to and does cause harmful and offensive contact to a victim's person or property. That's the rule in this jurisdiction. And then we're going to look at each of the elements, and those are going to be the sub-issues that require the sub-rules. So intent, right? Harmful and offensive. Contact, right? So these are all sort of separate elements, but you are going to list those, remind yourself of the rule, and then write facts in favor and write facts against. And I want you to think about this. So I always have students who resist. every year, every time I introduce this concept. And often there's students who have historically done quite well, and they think, well, most essay exams are racehorse exams. Time is really limited, so I have to get them done as fast as I can, and it's counterintuitive to use this planning time. And then I remind them that this is really the time, this learning and thinking and planning time during the exam, 1/4 of the allocated time before you start writing. This is when you're figuring out the entire answer. Once you have thought through it, jotted down your notes, so you have, each of the elements outlined here, and you're reminding yourself quickly of the rule and facts for and against, you know exactly what your answer is going to look like. So you have, your recipe, your roadmap. There's no figuring it out while you're writing. All you're doing then is smooth sailing and getting it on the paper or on the screen. And compare that to sort of figuring it out as you go along to save time. If you don't have a plan that you could sort of check off, okay, I've discussed that, I've used that fact, check, 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 the recipe to follow, you end up changing your mind in the middle. You end up repeating yourself. Did I talk about that before? I'm not sure. And the result is this mushy answer that kind of meanders each way in an effort to just get it down on paper. If you have a concrete plan, your essay is going to be much more focused and much easier to follow. And honestly, you end up saving time because you have directions that you're following. So I cannot emphasize this enough. This is a skill that you should practice when you do practice exams under timed conditions. Really, I feel that it is critical to your success, planning your answer. During the exam, you need to remember that most exams are 60-40, not 90-10. Okay, so the conclusion, which is what beginning students really want to hold on to, what's the answer, right? Because the answer historically has been what you've been getting the points for. That's not true in law school. The exams are not, written so that 90% of the students are going to go one way and 10% are going to argue the other. They are written 60-40. It's not clear what the answer is. There's one answer that might be slightly better as to whether or not, this person is liable, whether or not this claim can be brought, whatever question it is that you're answering, they're really designed to be 60-40. So that means, law students find this frustrating, but what it means is that you could have 2 A papers that actually reach a different conclusion. What matters is the big A, the application, the analysis, how the students use the rules, apply them to the facts, show their work to reach the conclusion. So the points are not in the conclusion. If you're not sure, and it really could go either way, as many law cases can, you can acknowledge it's close, but you have to pick a side, pick an answer. But know that if you walk out of that exam and someone says, oh, I definitely thought that was met, that was satisfied, and the person could bring a claim, and you reached an opposite conclusion, it doesn't mean you're going to do poorly. If you explained how you got there and applied the rules to the facts, you're good. And think about it in terms of filing briefs with the court. There could be an outstanding motion by one side asking the court to do something, and an outstanding opposition by the other side. And both are great pieces of writing that use the same rule, but they argue for a different outcome. They apply it differently to reach their desired conclusion that they would like from the court. So just keep that in mind when you are evaluating your exam answer. Block time and space, we already talked about that. Again, think strategically about the order in which you will answer. So, and I'm talking down to the minute. So not say, okay, quarter of a time, that's 20 minutes. I'm talking, it says the clock says 10:04, so I'm going to plan to organize and outline my answer until 10:24, right? Writing those things down for yourself. It's really important that you proportionally allocate time according to the facts provided, and if you're given a weight, certainly according to the weight. So what also happens, because nerves take over, is that if you don't have a solid plan that gives you specific times, you may get trapped in one area or element. And the result is that you're really minimizing the amount of points that you're able to get. So really having this plan, blocking time and space, and being strategic about the order in which you answer your questions will prevent you from getting trapped in one area or element. And now that you're listening to this and you're calm and you're not freaking out in an exam room, this sounds very easy. But the temptation to sort of work through something and figure it out when you're stuck often leads students to, pick up their head and realize, oh my gosh, there's only 10 minutes left. So paying particular attention to time is critically important to doing well on exams. This plays into what we talked about in the Intro to Legal Analysis video, which is the Intro to IRAC, but just to briefly touch on that, you're going to write using IRAC or CRAC, whatever your professor prefers, but we've learned that the reason you're going to do that is it's going to be easy for your professor and later on the court to find the information they need in your writing. And there are some basic introductions to that work that help remind you of what you're supposed to do. So, for example, when you're identifying the issue, you're saying the question presented is, right? Or the issue is. You're articulating the rule, so the general proposition of law. And you don't want to paraphrase the rule. You want a good, solid rule statement that includes all of the relevant legal terms. So under the restatement second, comma, the rule is for battery is blank. So under, using that word may remind you to articulate the rule. And then you want to apply the rule. And, it's often said that you want to give the professor more. So the main argument, the opposing argument, the other side may argue, right? But here's why that would fail. And then the rebuttal, if that's given to you. But to remind yourself to do the big a good way to transition into that is here, comma, and then talking about the facts, applying them to the law. Again, you have to reach a conclusion, even if it's close. So therefore, it's a good way to start that. Your goal should be for your answer to be as easy to follow as possible with proper spelling and grammar, but do not waste your time on beautiful prose. You are not going to have any great success by trying to write it very artistically or beautifully or make it sound super sophisticated. Actually, the best legal writing is simple writing. I had a friend who, and I've seen this with many people, who was an English major and really struggled out of the gate with law school. And it's not that English majors are at any disadvantage, but this particular student and students like her, they had always done well based on their style of writing and, received good results. But the problem was that those students aren't able to get through an exam quick enough, and they don't get any points for beauty or great style. You really get points for following the IRAC paradigm and identifying the things that you need to include and including that legal analysis and following these organizational paradigms. And so you really have to abandon, the writing that you're used to and embrace this formula. And the sooner you're able to do that and the more you're able to practice it, the more successful you'll be. So don't worry about beautiful transitions and making it sound great. Even if you just use the question presented under here, therefore, that is satisfactory. Your professor will be able to find the information. Okay, so this is important. After the exam, move on. Don't talk to anyone about the exam. You may hear the term, the grim term post-mortem, which is what is traditionally referred to when students talk to each other about the exam, following the exam. There's really nothing good that can come of it, because nobody knows exactly what the professor is looking for at that point. So, if someone reached a different conclusion than you, if you realized you may have missed an issue, maybe it's just one issue and wasn't even an important issue. It doesn't mean you missed all the points available on the exam. So really, you need to just let it go. It's not productive to rehash it or to go home and look over your exam. I have had many students over the years who have had a major freak out after the exam, thinking they failed, thinking they did so poorly. And I know that feeling, but it's never productive, because what happens then is that the student has so much anxiety that they're not able to focus on their later exams, and they do in fact perform poorly on those exams. So and odds are that the student didn't perform as poorly as on the exam that they're freaking out about. So that's not productive. The best thing you should do after an exam is just take some time to relax, get a good night's sleep, and focus on the next one. And if folks are really baiting you into having those conversations, put your headphones in, ignore your texts, silence them, do what you have to do for yourself to make sure that you are in the right mindset for the next exam. Now that we've talked about the basics of taking the exam and preparing for the exam, we're going to touch on some common exam mistakes. So these are your typical first year exam mistakes. One is poor organization. And the awesome thing about this exam problem is that there's absolutely a solution to it, and that is taking the time to organize and outline your answer. As we've talked about, if you don't, you'll end up repeating yourself, losing your way, and you will spend more time. So poor organization is easily remedied by taking that quarter of a time to plan and give yourself a roadmap and a written plan you could follow. Your thinking time. Another one is making assumptions. So nothing is obvious. So even though you think, well, my professor taught me that rule for battery, and so I don't have to put it down here because the professor knows that rule already, and the professor is reading this, that is a mistake, because the professor can't read your mind and is not able to give you the points you're looking for if you don't show your work by connecting the law and facts, right, for thoughtful analysis. So instead of thinking of your professor as the person reading the exam, write it as if a layperson just walking down the street who's never heard of these rules before, who basically is going to be your future client, right? Odds are that your clients are not going to have legal sophistication unless, I suppose, if you're working it with corporate clients and their legal department, that's a different story. But odds are, if you're dealing with the average person, they're not going to know what the rules are and how they apply to their case. So think of it through that lens and really lay everything out rather than assuming that the reader is going to know. Rules only. So as you've probably heard me say before, anybody can memorize a set of rules. So, that's not what you're going to get paid for as a lawyer. And really, the memorization piece we do because that's how the bar exam tests. In the practice of law, you are rarely, if ever, going to just rely on your memory. You're going to look up the current rule. Even if you know it, you're going to look it up to make sure nothing has changed since the last time you looked at it. What you really are focused on as a lawyer is not the rules. You need the rules to analyze the legal problem, but it's the analysis itself that's critically important. So rules only will show your professor that you sort of memorized the set of rules and that are important, but it will not show that you have a deep enough understanding of those rules to know how to apply them to a new set of facts. One of my mentors, Professor Susan Gillis at Capital University Law School, these are her categories that she often talks about when reviewing common exam mistakes with her students, and she's seen a lot of exams over time. So I thought I would mention those here. These are Professor Gillis's observations. So in her experience, there's law-based problems. So failure to state or understand a rule fully. So having the gist of the rule. And how you figure out if you have that deeper understanding, as we've talked about, is using the testing effect through practice exams and doing that back end work to figure out how strong your knowledge of the law is, how strong your outline is on a certain proposition of law in light of your attempt to answer a practice problem. Another common exam mistake is a fact use problem. So summarizing the facts instead of using the words provided. So as I've mentioned, professors spend a lot of time drafting their facts that they use on the exams. And there's a reason they state the facts the way they do. So don't just do a high level summary. The professor provided you those facts and wants you to use those particular specific facts when applying the law. And they want to see those back. So don't make the mistake of just summarizing. Really go back and figure out what facts you're going to use. And that's why that outlining again is so important, because you can put the specific facts in there and then you don't have to keep going back and forth between the fact pattern. All you have to do is look at your exam, or at your outline. The other one that she talks about is, she calls it one and done. So finding one fact that looks like the element is met or not met, and then moving on. So you want to try and use the full range of facts. So this goes back to, there is almost never a sentence in your fact pattern without meaning. It's there for a reason, and so you want to make sure you use the full range of facts to get the full range of points. And so one way to test this when you're doing the back end work with your practice problems is that when you're checking to see if you use the full range of facts, every time you use a fact in your answer, highlight it in the fact pattern. And when you're done, almost every single sentence should be highlighted. And if not, then you may be suffering from a one and done, or perhaps two and done problem. And see how you really could have used the full range of facts to rack up some additional points. Writing problems. So reciting facts, but not using them. So fact listing and not marrying the law and facts together. So you're putting the relevant fact in there, but you really could have just lifted it from the fact pattern. That is not what you want to do. You want to be sure to tie it to the rule words, to tie it to that law. And the best way to do this is to use those law words and fact words in the same sentence. And you can do that highlighting trick to make sure that both are present to constitute legal analysis. Okay, so studying mistakes. Again, if you know a bit about learning science, you may be familiar with the concept of interleaving. And what that means is moving between subjects and topics is better to boost understanding and retention. And this is also often seen from a pedagogical standpoint in terms of how we should teach, but it can apply to your studying as well. So, for example, if you're going to have essay questions and multiple choice questions on your contracts exam, mix it up and do an essay or two, then mix in some multiple choice. Don't have a whole day dedicated to multiple choice, a whole day dedicated to essay writing. Really try and mix in different approaches. And that goes for subjects as well. So, maybe you divide a day in half instead of devoting one day to a subject, because switching between subjects and topics is harder. And when learning is harder, it leads to better results. And when you're studying for exams in particular, if you do that exam by exam approach, there's no way your last exam, or perhaps your last two exams, don't get short shrift. So throughout the semester, interleaving is something I want you to at least be familiar with and thinking about. Learning should feel uncomfortable. desirable difficulties. It should feel hard. And if it's not feeling hard, then you're not stretching yourself. And if you're not stretching yourself, you're not maximizing your learning. So that's the concept behind interleaving. We've talked a bit about the testing effect. It's critically important. That's the first thing that I ask students when they come to my office after performing poorly on an exam is how many practice exams did you do? How did you do them? And what did you do with your practice exam answers? I can't emphasize that this is critically important. Can't emphasize it enough. Practicing rather than passive study, even to quizzing yourself with flashcards and things, increases long-term retention. And that's not just looking at one side of the flashcard and flipping it over and looking at the other side of the flashcard. It's really testing yourself. So making yourself say it aloud, perhaps writing down the answer, really hold yourself accountable to an active way of studying rather than a passive way of studying, because a passive way of studying just doesn't work in law school and it's far less efficient. Doing the back end work that we discussed, you can use practice exams multiple times. So here I have my free throw analogy, but if a professor gives you something to work on and you write it once and you do the back end work, set it down and then try it again. Rewriting is an excellent way to study because it really, again, solidifies the work you're doing there and your knowledge of the rule and your application to a given set of facts. This is just something that I've come up with over the years because I've seen this in various iterations, and this goes into like the helpful and unhelpful thinking styles. There's a lot of compare and despair in law school. My colleague has the best study aid, but I can't afford it. They have the best legacy outline, someone else's outline who performed well. That's not a helpful thinking style. And usually those things that you're thinking, that the other person has it all figured out, that the other person has the best internet resource or the best, study group and you're not part of it. Usually those things are not necessarily true. All that matters is what pertains to you and that that learning should be hard. And there aren't any shortcuts. There's no magic formula. You have to embrace the desirable difficulty, embrace the hard. So many students spend a lot of time searching for that key, that magic formula, trying to find the right study aid, collecting a number of legacy outlines. It's a waste of time. It really is. The best thing that you can do is actively engage with the material and not just stare at it, not be passive, and really take the time to use your professors as a resource, whether it's going to office hours and asking questions, reviewing videos that they have posted online. If your professor, writes something on the board, if your professor gives you a handout, good God, complete it. Like, I'm always amazed. It's so important. They're giving you what they think is important. Don't look for something else instead. If you're struggling with that, that's fine. This is supposed to be hard. You're not supposed to get it right away. Use your professor as a resource. Confer with your colleagues, your fellow students to try and figure out the answer. And again, rewriting is a really good way. So if you have worksheets or practice essays, try them again and again. That's perfectly fine. You're going to improve each time. And each time that information is getting further ingrained in your neural pathways, as is engaging with the IRAC paradigm in writing an answer. Similarly, don't isolate yourself during law school. You really do need to confer with your colleagues. The practice of law is extremely collegial, more so than we emphasize in law school. Rarely will you ever, just deal with a case from its inception without talking to a colleague about it, without going over a draft brief or perhaps mooting an argument with them. It's a very collegial practice, and these people that you're going to law school with are your future colleagues. So start now. By working alone, you are not really going to be forced to, articulate and explain your understanding. So this does not mean that you have to have a study group. Study groups can work really well if they're done well, and I have a video on some guidelines for study groups, but they can also be a huge waste of time if it turns into socializing, if one person really cares and is digging in and the other person is just passively going along. So they can work. I'm not arguing against study groups. I just want to say that you don't necessarily need a study group. You need one or two people, they don't even necessarily have to be your friends, that you could go to clarify a question. If you miss class because you're ill or something, you can, ask to borrow their notes. You can review practice exam answers together, talk through legal issues. Um, but isolating yourself may give you a false sense of, okay, I've got this. And sometimes you aren't aware that you don't really understand something until you try and explain it. And heaven forbid, you don't want to figure that out for the first time while you're in an exam. So my study buddy, who I met in law school, is my best friend to this day. And we're an interesting match because she's significantly older than me and was in a much different place in her life when she went to law school. It was a second career for her. But boy, there's nobody on earth who I value more as a friend than her. And so, just find that person for you or those people for you, because it's really hard when you isolate and go it alone. Law school is a mental game. So we are all anxious these days. It's across the board. Rarely do I meet anybody who's not anxious. I'm recording this in the midst of COVID and some of the protests that are happening across the United States. And it's scientific fact that our society, anxiety is high, and then you put law school on top of that, and it certainly raises anxiety. Don't let your anxiety and fear inhibit your progress. Know that learning is uncomfortable. Know that you're not going to be an expert. You're not going to be perfect. You're not going to find the perfect way to study. Just do your best to engage with the material. Tell yourself you can do it, even if you don't believe it. And focus on mastering the information and engaging with the information in an intellectually curious way, as opposed to the outcome, as opposed to, I want to get an A, right? That's not going to be beneficial to say, I have to get all A's. What's going to be beneficial is saying, I'm going to learn this doctrine as best as I can. And I'm going to learn to apply it to new facts because I'm really interested in what a lawyer does and the way the lawyer thinks. And I'm going to keep practicing it and have a growth mindset. And I'm going to stay after it until I feel like my skills are built. So don't be hard on yourself and make this harder than it is. And you may be somebody who has never had any mental health issues, really hasn't suffered from anxiety before, but law school and the competitive nature of it is bringing this out in you. There's no shame in going for help. Most law schools have law school counselors, so mental health professionals who can talk you through this, who deal with law students all the time. So don't feel like you're the only one. It's very common to have that feeling. And if you need help, get it. As I said, sometimes mental health issues are discovered or come about for the first time in law school. Sometimes learning differences and really bright students who have never had to address maybe ADD or ADHD before, and the students realize for the first time in law school, oh my gosh, I think I might need to be tested for something. My focus is not great. Don't get down on yourself. Those are normal things. And the great thing is that there are ways to address those if you get it connected with the right resources. And law schools will connect you with the right resources. So be kind to yourself. And as always, know that you can do it, and I will be here rooting for you. Thanks for your time.